In this video, we are going to discuss remedies in judicial review. Let us start with constitutional remedies. The judicial control of administrative action provides a fundamental safeguard against the abuse of power. The Constitution was built on the deep foundation of the rule of law. The framers of the Constitution made sincere efforts to incorporate certain articles to enable the courts to exercise effective control over administrative action. These articles are 32, 226, 136 and 227. Article 32 is right to constitutional remedies. Under this article, Honorable Supreme Court has been empowered to enforce fundamental rights guaranteed under Part 3 of the Constitution. The Supreme Court has power to issue appropriate directions, orders or writs, including writs in the nature of habeas corpus, certiorari, mandamus, prohibition and quo warranto. Under Article 226, similar powers have been conferred on the respective high courts for the enforcement of fundamental rights or any other legal rights. It empowers every high court to issue directions, orders or writs to any person or authority, including any government, in relation to which it exercises jurisdiction. According to Article 136, Supreme Court can grant special leave to appeal. This article conferred extraordinary powers on the Supreme Court to review all such administrative decisions which are taken by the administrative authority in quasi-judicial capacity. Then, according to Article 227, High Courts have power to have superintendence over all the courts and tribunals under its jurisdiction, except the tribunals constituted under any law relating to armed forces. Second type of the remedies are statutory remedies, which are of two types: statutory appeals and reference to High Court or statement of case by an administrative tribunal to the High Court. There are some acts which provide for an appeal from statutory tribunal to High Court on the point of law. We may take the example of Section 30 of Workmen's Compensation Act 1923. While there are several statutes which provides for the reference or statement of case by an administrative tribunal to the High Court, for example, Section 256 of the Income Tax Act 1961. Now let us move to ordinary or equitable remedies. The word equity has been borrowed from morality. It is the voice against injustice caused by the rigidity of law. Though it is not synonymous to natural justice, it demands that justice should be made in accordance with the circumstances. Equity is applicable to the circumstances in which the provisions of law may prove to be unjust, and if necessary, the provision should be made flexible to stop this injustice caused by the rigidity of law. Apart from constitutional and statutory remedies, there are some ordinary remedies based on this principle of equity, which are known as equitable remedies, which include injunction, action for damages, and declaratory actions. An injunction is a preventive remedy. It is a judicial process by which one who is threatening to invade the rights of another is restrained from continuing or commencing such wrongful act. Injunction may be prohibitory or mandatory. Further, prohibitory injunction is classified into interlocutory or temporary and perpetual injunction. If any injury is caused to an individual by wrongful or negligent acts of the government servant, the aggrieved person can file a suit for the recovery of damages from the government concerned. This aspect of law can also be seen in the topic liability of state or government under the law of torts. Declaration may be taken as a judicial order issued by the court declaring the rights of the parties without giving any further relief. Thus, declaratory decree declares the rights of the parties. In such decree, there is no sanction like ordinary judgment against the defendant. It is an equitable remedy, the purpose of which is to avoid further litigation by removing the existing doubts with regard to the rights of the parties. In this way, there are different judicial remedies available for different circumstances. After observing all these remedies, we may conclude that judicial remedies are available to avoid injustice, to avoid infringement of the rights, and to maintain the rule of law in the democratic state.